I will speak English, and I wish first of all to thank for the opportunity to be here today. So thank you so much. I would then shift briefly to Italian to greet LUMSA in particular, but let me first in English thank St. John's for having me here today. The Dean of the Law School, first of all, whose photo in the Osservatore Romano today is a great reminder of that great moment yesterday. And thank you so much, of course, to the other colleagues from St. John's, Professors McGuinness, the Geronimi Movsesian. It's a great privilege to be here. Let me briefly, no need to take the headset on. Let me briefly shift to Italian to say thanks to LUMSA in my native language. Vorrei ringraziare per l'onore di essere qui all'Università LUMSA nella persona del rettore professor Dalla Torre, i colleghi della LUMSA, della mia comunità del diritto ecclesiastico e canonico che sono qui, gli altri colleghi sempre della mia comunità che è quella del diritto ecclesiastico e canonico che sono qui e Monica in particolare. And I'd also like to say thanks to all those from St. John's and LUMSA who made our event so pleasant and kind and well organized, both yesterday and today. It's been really a treat all throughout. And thank you so much also to translators for the effort of translating my Italian, Flemish English into an Italian. And I'm really sorry to have a PowerPoint presentation, but it would be much easier for me. Someone recently said, I think a British politician said, power corrupts, but PowerPoint corrupts absolutely. And sorry for this, but it would be much easier for me to follow. So it's 9:32. I will be finished by, we have 20 minutes each. I will be finished by 9:51, since I took already 1 minute at least. So my presentation has a threefold structure, as you see. I will first, in the first part, concentrate on divergence and convergence. I mean divergence and convergence amongst European states. And the first part will be on the effect. What effect, how convergence and or divergence have on the protection of freedom of religion or belief in Europe. The second part will be a more descriptive part, stating what's the state of the European standard in the protection of religious freedom and belief, what I see as an emerging European standard in this area. The third part will be the more personal one, and it will be about a statement from myself about the need for further convergence. So let me start from the first, the impact of divergence convergence on freedom of religion and or belief. And let me start from this resolution. This is Council of Europe. It's not, for those who are not familiar with the European structure of intergovernmental, international or regional relationships. This is a much bigger organization than the European Union itself. This is Council of Europe. The Council of Europe as a parliamentary assembly, which again should not be confused with the European Union Parliament. And this parliamentary assembly on April last year approved a resolution on the protection of religious communities from violence. I take this example as an example of European convergence. A quote from the text at number 14, the European Union in its political dialogue with non-member countries should enhance its monitoring of the situation of communities and individuals defined by religion or beliefs. Let me point at the two aspects. Acknowledgement of a situation, acknowledgement of a problem with religious freedom. And second aspect, the need for a European action. Second example, most well-known, 1 year ago, almost. This is the European Union, no longer the Council of Europe. Smaller organizations in terms of countries represented. And this is not the Parliament of the European Union. So this is the Council, this is governments. These EU guidelines have been approved, which are described in this text, number 8, as meant to explain what the international human rights standards on freedom of religion or belief are, and give clear political lines to officials of EU institutions and EU member states to be used in context with third countries and with international and civil society organizations. They also provide officials with practical guidance on how to seek to prevent violations of freedom of religion or belief, to analyze cases, and to react effectively to violations wherever they occur in order to promote and protect freedom of religion or belief in the EU's external action. So let me stress this further element. Convergence in Europe in the perspective, under the angle of external action. And again, of course, acknowledgement of violations. A third example is rather an example of divergence amongst EU member countries. And this is back to the Council of Europe framework, this time a court, the Court of Strasbourg, the Court of Human Rights in charge of the application, supervision on the application of the European Convention on Human Rights. This is a case where the Romanian government and the Romanian Orthodox Church felt that the application for registration of a trade union made of priests of the Orthodox Church threatened the internal autonomy. There has been debate amongst experts on the meaning of all this in terms of law and religion. Someone squarely argued, also based on the for a sort of analogy with the summum case for our American colleagues, in terms of a threat to sort of ministerial exception, threat to the autonomy of the church. Others, minority position like myself, to be honest, rather argued that what was at stake here was the power of the state on the church, not the power of the church to regulate itself. Since the registration under state law of a trade union, I argue, doesn't imply as such anything for the internal structure of the church. So a trade union, I believe, can be registered under state law, and there's no obligation, because of this, for then the church to recognize any power in the internal structure of that trade union. No more than a civil marriage of a priest forces any church, and Catholic Church in particular, because of celibacy, to then keep or not excommunicate that priest. But the understanding of our Romanian friends, and I understand that, based on a establishment system, so state powers on the church, made them understand that if something is recognized by the state, then it's compulsory for the internal structure of the church. So this is just to give you a sense of how sensitive and complex the case was. Anyway, the case was then decided by the Grand Chamber on the appeal, July 2013, in the sense of protection of the church autonomy as associated to a protection of the diversity of the Romanian government with regard to other European systems. And the understanding of this legitimate divergence is stated there. The court, I quote, takes note of the wide variety of constitutional models governing relations between states and religious denominations in Europe, having regard to the lack of a European consensus on this matter. It considers that the state enjoys a wider margin of appreciation in this sphere. End of quote. So it's not for European judges, it's not for the British or the Italians or the Germans to say what Romania should be about and what the Romanian church should be about. And this has been, as you know, welcomed as a decision in favor of religious diversity and religious autonomy. Now, an example from the same court of rather convergence, somehow opposite to the previous example, because here we have the court a few months ago, April this year, rather arguing in favor of a strong European supervision, strong European powers. It's a case concerning an act passed at the Hungarian parliament, which de facto deregistered some denominations, requiring them to register again in order to acquire a new status of registered churches. And the Court of Strasbourg condemned Hungary in the end in this decision for that. The basis is, contrary to the Romanian case, an affirmation of an advancement of the European supervision. Let me quote again. You will remark the sort of analogy, the comparison with the previous case. I quote, although the states have a certain margin of appreciation in this field, this cannot extend to a total deference to the national assessment of religions and religious organizations, and the applicable legal solutions enacted in a member state must be in compliance with the court's case law and subject to the court's scrutiny. Final example for my first part. Going again back to convergence, this is a resolution, again, passed at the Parliamentary Assembly of the Council of Europe, April this year. There was an attempt by a French member of this assembly to have the assembly pass a resolution against sects, against sectarian excesses, which would be very much a certain understanding of a French laïcité, molded on the dérive sectaire, the anti-dérive sectaire initiative by the French government, which is, by the way, pretty outdated at the moment in France. And in fact, this was an attempt to renovate something which was losing momentum in France itself. Now, not much of a resistance against this resolution from member states, not much of resistance from mainstream churches in Europe, pretty silent at this. Of course, those who were mainly attacked were the most proactive in leading a campaign about the adoption of this resolution, Church of Scientology first of all. And in the end, the resolution is a strange animal as it has been approved. It still has some flavor of what it was meant to be. There's still some reference to this danger of sects. But in the end, the Church of Scientology and others managed to have it recognized that there's no legitimate distinction between sects and churches. And that's the relevant passage here, where some European convergence can be found. So I would just quote the passage he read. No distinction is made between traditional religions and non-traditional religious movements. Against this oscillation between convergence and divergence, we have an emerging European standard. In my paper, I discuss at length the many points. For the sake of this presentation, I just selected a few. A first point would be no state discretion in assessing the legitimacy of beliefs. This point has been made clear in particular by the Court of Strasbourg in cases like this one, a Greek case where the court declared the right of freedom of religion as guaranteed under the Convention excludes any discretion on the part of the state to determine whether religious beliefs or the means used to express such beliefs are legitimate. This is the court. The European Union, in the Charter of Fundamental Rights, has stated a very important principle of religious diversity. European law respects and promotes diversity of religious as well as non-religious worldviews. Third very important point is strict scrutiny of admissible restrictions to FORB, both based on the Article 9 of the European Convention, second paragraph, and also based on the interpretation offered by the Court of Strasbourg. A further point is what has been described by the Court of Strasbourg as the state's neutrality and impartiality of the state. And another aspect is religious autonomy, which has been described very much in line with our international literature as, in these terms, in the case of Fernandez-Martinez, Spain, which is a judgment that has been sort of confirmed by the Grand Chamber 1 week ago, and this passage is from that decision 1 week ago, where the organizational life of the community not protected by Article 9 of the Convention, all other aspects of the individual's freedom of religion would become vulnerable. Now, what this decision added last week is something new to the jurisprudence of the Court of Strasbourg, which is that there is no right to dissent within a religious community which can be considered as protected by the European Convention as such. The case being about some dissent within the Catholic Church, so that's why the argument was made. Let me come to my final part. How and why do I suggest that we need a stronger, a stronger convergence in European law of religion? I will try to make myself clear through two passages from the EU guidelines on freedom of religion and belief, last year's document, which is now meant to guide the EU external action. The problem with the EU external action in this field is on what do we build a European credibility. And here we have two options. One option could be what some critics of the American model would see as a double standard. So I'm fine with religious freedom within my borders. I'm a model of religious freedom. Europe is a model of religious freedom. And therefore, I'm entitled to fight all over the world where that freedom is not respected. The alternative would be, I'm committed to fight violations of freedom of religion in my country, in the case of European Union, in my countries, because I know that there are violations. I'm not blind when it comes to what happens in my land. And since I'm committed, I'm credible, and I'm legitimized to export, to fight all over the world. So this was the way which was adopted by the European Union. So first of all, when it comes in the guidelines to recognition of where violations are, there is a clear statement that the European Union is committed to find, to recognize, to acknowledge and fight violations wherever they occur, including, final part of this text, Europe. In all parts of the world, including Europe. Europe is not safe from violations of religious freedom. Based on this, there was a further step, which is, of course, continuing on the comparison with the US, not needed in the US thanks to the First Amendment, but very much needed in Europe, which is, what is the European Union vis-à-vis religion? And in the same document, number 7, there was a clear statement about the impartiality. The European Union is impartial and is not aligned with any specific religion or belief. Now, this is an example of European convergence, but this is also an illustration that if this is the way which is taken, further convergence will be needed. A European conversation will be needed on how to acknowledge and face internal violations and how to make a European action respectful of diversity more efficient. Thank you.